Sitting on a jury and deciding whether a person is guilty or not is a huge responsibility.
Has the jury reached a verdict on charge 1?
Guilty.
Trial by jury, a cornerstone of the legal system.
Today, a jury found he had attempted to kill another that day.
After a 7-week trial and 10 days of deliberations, a jury has found Christchurch man John Hope Muchirahondo guilty.
They spent more than 40 hours deliberating, which is the longest a jury has taken in New Zealand in recent memory.
The charge of murder. Do you find the defendant, Philip John Polkinghorne, guilty or not guilty?
Not guilty.
The jury of 3 men and 8 women also found the 71-year-old not guilty of manslaughter.
As you can imagine, we think it's a crap decision.
Jurors don't always please the public gallery or defendants, and they don't always agree with each other.
After 15 hours, the jurors declared they could not reach a unanimous verdict. They were told to go back and see if they could reach a majority verdict, which they did, 11-1.
Guilty of murder. Guilty of murder. Guilty of murder.
We heard jurors crying as they left the room. Their job has been such a difficult one.
It's now being proposed that fewer Kiwis will face that difficult job. Kia ora, I'm Amanda Gillies, and on The Detail today, the changes proposed for jury trials. The government is considering raising the threshold for a defendant to choose a jury trial in a bid to speed up the court system. That means more judge-alone trials, but not everyone's convinced. Here's specialist criminal defence lawyer Tom Newman.
There is this phrase, hanging judges. As a criminal defence practitioner, certainly there are judges that you would not want defendants appearing in front of for a judge-alone trial. They're just much more likely to convict than a jury.
Justice Minister Paul Goldsmith has cited jury trials as one of the biggest drivers of delays in our courts, so he sought public feedback on a proposal to fix those delays. Submissions have now just closed. A decision is expected in February. Currently, defendants can choose to face a jury rather than a judge alone when charged with a criminal offence carrying a maximum prison sentence of 2 years or more. Under the new proposal, that threshold would increase from 2 years up to either 3, 5 or 7 years, and defendants would be allowed more time to make their decision on whether they want to be tried by a jury. Here's Goldsmith talking to News Talk ZB in September.
My main concern is that too many people are having their lives put on hold for years, waiting for an outcome of a court case or if it's a civil case, waiting for a resolution to their problems. That the times have blown out. COVID obviously had a role, but it's been too slow for too long, and so I've got a real focus on trying to speed up processes of the courts. And we're pulling many levers, trying many different things. One of the things that has driven the blowout in times has been more people electing for jury trials. And so we're just asking the question, we're going out for consultation to say, well, it's set at 2 years currently. What do people think about 3 years, 5 years or 7 years? 7 years would be a big change, and it would certainly have a huge impact on the overall efficiency of the courts. But of course, you've got to balance that against the ancient rights. And so I think it'll be an interesting discussion. I think we should lift it. It's just a question of how far.
But what do lawyers and defendants think?
I prefer a jury trial. For the trials that I did, they definitely affect issues of what is common sense in the everyday person, what are the morals, what's accepted, and people who are on juries are more likely to have experienced firsthand or within their family the issues that will come up in a jury trial more than a judge.
Marie Dyberg is a top defence lawyer in Auckland, so does she see any positives in the proposed changes?
No positives at all where I'm coming from. It really threatens what we say is the fundamental protections under the Bill of Rights, like Section 24E, which enshrines your safeguard for the right to, trial by a jury. But a jury trial is so deep-rooted in protections for people who are facing courts. In theory, it protects individuals from, arbitrary state power. And your state power is through the judges. So therefore, of course, when you say, well, what's the state power? It's actually through judges who are appointed by the system. They represent the legal profession, the Justice Department. But in terms of where does a defendant stand? They stand alone, they stand outside, and of course the Crown pretty much stands with the system. So that's really like that theoretical basis for it. But of course, the other side of things that we say is that what is a jury? What does it actually do? They really reflect the moral standards and what's common sense out there on the community. How does the community see conduct, behaviour, and what people do when they are charged? What is acceptable and what actually crosses that line? And judges are really bound more by more legal boundaries, that they can't really do the same thing. Like juries, they bring collective wisdom. They foster trust in the justice system and they promote legitimacy. And so for us, it checks judicial powers in terms of who really understands what goes on out there in the streets, in the homes, out there in the community. And they see judges as being removed and they see judges as being elite. And so therefore clients that we have would much rather put their faith in the jury, people who understand, than a judge who they see as they're not really into the community and understand the community. They don't understand violence, family violence, self-defense, all of those things that juries do. So that's sort of the opening gambit, really.
And those are sentiments backed up by both our former Chief Justice, Dame Sian Elias, and then Supreme Court Justice Sir John McGrath, in summing up the importance of the jury. In a case from 2012, they said,
"Jurors bring a diverse range of perspectives, personal experiences and knowledge to bear in individual cases which judges may lack. Jurors determine which of the evidence presented at a trial is to be believed and acted upon, and they reflect the attitude of the community in their determination of guilt or innocence."
That case law also said that
the right to trial by jury is also generally seen as providing a safeguard against the arbitrary or oppressive enforcement of the law by the government. The jury is seen as standing between the accused and the state in a way that judges, who are sworn to apply the law, are not always able to do.
So that came from the highest court. That's how they see it.
So can we sort of trust judges to be impartial, or are they more likely to convict?
One is it's a perception. At the trials I do, it's not so much a corrupt bias, but I know that I can appeal more to the layperson as to why people behave in a particular way and why they don't. I can appeal to them by saying, a complainant behaved in a particular way. If they were telling the truth, would they do that because of these reasons? And I know that I strike a chord of understanding, and this is general, but primarily for me, is that I strike a chord with the layperson far more than judges. And that's the reason why, for me, I would always prefer a jury trial.
She is not happy about the prospect of raising the threshold of criminal punishment from 2 years just to save the justice system some time.
You are cutting off a huge number of people who are entitled to a jury trial. And when you compare the other jurisdictions, international jurisdictions, some of the main ones are a lot less than the 2 years. But 2 years covers quite serious charges. They are certain assaults and those sorts of charges, which are, of course, are devastating if you get convicted on those things. That's life. When you get a job, you're not going to be able to travel in the same way. So therefore, your right to a jury trial should be for matters that are really going to cause you a lot of concern and grief should you get a conviction on that. And so, of course, the way that it goes now is that you've got access to software that allows you to find out if you go for a job, if you've got convictions or not get convictions. So what you actually then have, of course, is a problem that these are matters that will affect you lifelong. And therefore, if your case is going to be better decided and better judged in the long run by a jury, that is something that you should not give into. That's something that you should really fight for.
When it comes to appeals, Marie, is it more likely, or are you more likely to have success with a jury trial or with a judge-alone trial?
Well, you will have more appeals available to you if it's a judge alone, because they have to give reasons for their decision. So they are more vulnerable, of course, to get their reasons right as to why they found their convictions. Whereas jury trials don't. So you've got to really show a real flaw in the process. So you are going to be open to more appeals, of course, if you are in a judge alone.
What about judges? What are they saying and other lawyers and advocacy groups? Is anyone for these proposed changes?
No, there's certainly the Law Societies, Defence Lawyers Association of New Zealand, the Law Association. They are fighting really strongly hard against it, very hard, because these problems and delays are systemic that can be cured. And if you're going to start fiddling around with stuff that are really incredibly important principles, such as the right to a jury trial, guaranteed by the Bill of Rights, ancient right going back to the Magna Carta, I even know the date, 2015.
I'm impressed.
No, well, I've got a note here. So, no free man shall be taken or imprisoned, but by lawful judgment of his peers. And it's the constitutional value and significance that will be lost for mere expediency. And you can get it a lot faster if you sort out the system itself and not deal with the fact that you've either got a judge alone or a jury trial. So again, the argument can be is that, well, you can just wait a bit longer to make your election. But I think if you make your election early and you say, right, I've got a jury trial and you give me a jury trial in 5 months, I'll be ready, I'll be there, and I'll just work on that as long as I am not looking at adjournments, so that I can do my trials a lot faster. You get a jury trial or, a judge alone, and you have no real guarantee that it may go ahead. You don't ease off, but you get more time to prepare. But we used to have 2 great trials in a week, and we would get trials really early because the system allowed for it. None of these big, as I say, none of these big pre-trials that take up all your time in the court time, and you have to do these massive submissions when we all know what it is, and let's use some common sense here.
So let's talk about the delays that prompted this proposal. This is former Crown Prosecutor Henry Benson-Pope talking to RNZ.
There are real human costs to delay. Obviously for defendants, as you point out, who may be waiting trial in custody or on restrictive bail conditions, for their families too. Also for complainants and other witnesses who may be waiting for their day in court, I suppose, and being impacted by the delay as well. There's also evidential concerns. The longer a case is delayed, perhaps there become issues with witness availability. We know that memories fade over time. So it is important that the government takes steps to address delay, and I know the courts and government are doing that. But I think the question is, do we need to wait for more time to see if those other measures are working before we take the step of restricting the right to jury trial to try and solve issues with delay?
The number of active jury trials climbed from about 2,006 years ago to about 3,400 last year, with the average duration of a case from start to finish climbing from 349 days to 498 days over the same period.
We're seeing an increase in defendants electing jury trials over judge only. Latest numbers show nearly a third of cases closed last year were jury, compared with less than a quarter if you go back 4 years.
So, why the increase?
Well, some of the increase is that lawyers and their clients believe that they will get a fairer response to have a jury trial rather than a judge alone. And whilst they're talking about delays, you are finding that you can't resolve things. When you're in a judge alone, you're dealing with the police, they are tougher to resolve things. But a jury trial is what people are seeing as the better and fairer forum, and the forum that your clients are more likely to accept in an outcome as having been fairer to them. So when you say why the increase, you have to look at a number of things. One of them is, well, why is it so hard? Why do the public not have that same faith in a judge alone that they do have in a jury?
So, okay, they talk though, we've got these huge delays, these backlog is massive, court efficiency isn't good. How do we deal with that?
Well, you see, it's systemic for a start. You're going to have the same issues with judge alone if you then start flooding judge alone into the system. Because with a judge alone trial, you don't have that decision that's given at the end of the hearing. So judges have to go away, review the evidence, give reasons for that. And judge alone trials are subject to the same systemic problems. If you had, like, one of the worst things we've got too much administrative delay in the very beginning under the Criminal Procedure Act. What the problem with that is that it's a long time coming. You don't get the formal statements from the Crown. They don't have to give you what the evidence is going to be until after you have a case review hearing. That can be a good 2.5 months to a case review. Then you move on, then you get the statements, then you get call over. And so you've got a waste of up to 4 or 5 months before you actually get a trial set down. You can try and get disclosure a lot earlier. You can get people who are qualified, senior counsel, to do what they do in the UK and have their recorder system where they can sit in on the more lower level judge alone trials that don't need a district court judge, and they can hear those lower levels, which would free up trial judges to deal with those. We also have masses of pre-trial time as well that takes up getting towards trials. I can remember when we were doing trials years ago, we would just deal, at the moment you go in and say, right, I've got a pre-trial, whether or not somebody should give evidence by video or not, or we've got inadmissible stuff. Let's thrash all that out without having to file masses and masses of written submissions, and then set the court time aside for 1 hour, 2 hours, 3 hours to hear all these pre-trials. Judges before, they could deal with that stuff in a trial, and a lot of those pre-trials don't need to be dealt with beforehand. But that takes up a lot of court time as well. You can certainly streamline it, a lot better than what we're doing a lot earlier. You can certainly free up use of AVL technology, all of those things, and they can significantly reduce time and costs associating with transporting defendants, witnesses, especially for your preliminary hearings.
If he does come back in February saying, yes, actually we are going to make these changes, lift it to 3, 5 or 7 years, can you appeal?
No. If that's what the government says, then that's what we've got. All we can do is try and persuade them first now and say no. And as I say, other countries, ones that Canada and the US and England stuff, in Australia, they do not see the need to increase the threshold, why do we think we should? You have to have a really good reason, and the reasons are not made out. It will not bring about the aims that the government want. And the aims are good, but that it will not be achieved by this. They have to change that early system.
She would also like to see a change in attitudes towards jury service. It's a Kiwi's civic duty to turn up and serve.
If you're on the electoral roll, you can be asked to serve on a jury once every 2 years, but it turns out lots of us find excuses to get out of it, or worse still, don't turn up at all.
Part of the problem is the time it takes. Trials can last weeks, and the pay. Well, the maximum payment for jury service is just $80 a day. You can kind of understand the no-shows.
Only 17% made it to court when getting the call-up. A fifth of us pulled a no-show and didn't even have the absent note from mum.
Why is it so important to turn up, be keen and serve on a jury?
A lot of people don't want to. Those who do serve on a jury after it's over usually say they're glad they did. But of course, it's too easy to get out of a jury trial as well, you know, where you just plead employment. You should be tougher, but also you should be paying jurors more. You know, that they are paid hardly any money whatsoever, and yet they perform one of the most important constitutional function in the criminal justice system. So too many people, it's too easy to get out of it.
And is that part of the court delays, do you think? People aren't turning up or will go there and say, actually, I want to be excused?
We're not so badly off here, and we don't seem to have that sort of problem of not having enough jurors. But what you really want are jurors that are real across the board. You don't want those who are mainly students or mainly young people or mainly people from any of the sort of races. You really want to have people across the board to maintain that faith in the jury system.
On a personal note, if you were to be charged with a crime, Marie, would you put your fate in the hands of a jury or a judge only?
Always in a jury for me.
That's all for today. The Detail is a newsroom production supported by RNZ and New Zealand On Air. Thank you to Marie Dyberg and also to Jose Barbosa. This episode was produced by Alexia Russell and engineered by Phil Benj. I'm Amanda Gillies. Mā te wā.